Welcome to another episode on the Law Rapport. Today, I would like to discuss the right to silence in criminal cases. As a matter of disclaimer, this is not legal advice. For legal advice, please contact a competent attorney of your choice. The right to silence is a legal principle which guarantees an individual the right to refuse to answer questions from law enforcement officers or court officials. It is a legal right recognized constitutionally or by convention in many legal systems around the world. Under Section 5, subsection 5 of the Turks and Caicos Islands Constitution, the right to silence is protected, and in my view, it's an absolute right. Section 5, subsection 5 says that every person who is arrested shall be informed as soon as he or she is brought to a police station or other place of custody of his or her rights under subsection 4, and he or she shall also have the right and shall be informed at the same time that he or she has the right to remain silent and to have one person informed by the quickest practicable means of his or her arrest and his or her whereabouts. And subsection 4 guarantees a person the right to an attorney without delay, the right to an attorney of his choice, and the right to have secure and private communication with that attorney. So in my view, the right to silence and the right to an attorney are fundamental rights protected by the Turks and Caicos Islands Constitution. The right to silence protects against self-incrimination. Under the English legal system, some legal scholars have attributed the origin of the right to silence to Sir Edward Coke's challenge to the ecclesiastical court and their ex officio oath. And for viewers' information, Sir Edward Coke was a barrister, a judge, and one who was considered as one of the greatest legal minds of his time. The Fifth Amendment of the United States Constitution also protects people from being compelled to give testimony that would incriminate them. The right against self-incrimination was formalized in the United Kingdom in the year 1912, when the judges of the King's Bench issued the Judges' Rules, which was revised in the year 1964. The rules provided that when a police officer had admissible evidence to suspect a person of an offense and wished to question that person about the offense, the officer should first caution the person that he or she was entitled to remain silent, and anything he or she said may be used in evidence against them. The United States Supreme Court decision in the case of Miranda versus Arizona in 1966 gave us the well-known warning known as the Miranda Warning, which require police officers to cease any and all interrogation once a person invoke their right to an attorney, and it holds that any statements made afterwards are inadmissible in court. This only applies, however, after police officers have advised the person of their Miranda rights, which they are only obligated to do once they have placed that person under arrest. The right to silence is different depending on which UK jurisdiction. In England and Wales, an adverse inference can be drawn from an accused person's silence during questioning. The same is true for Northern Ireland under the Criminal Evidence Northern Ireland Order of 1988, but no adverse inference may be drawn in Scotland under Scottish law. Following the enactment of the Criminal Justice Act in England and Wales, adverse inferences may be drawn in certain circumstances where the accused, 1, fails to mention any fact which he later relies upon and which in the circumstances at the time the accused could reasonably be expected to mention. 2, he fails to give evidence at trial or answer question. 3, he fails to account and arrest for objects, substances, and marks on his person, clothing, and footwear in his possession, or in the place where he is arrested. And 4, if he fails to account and arrest for his presence at a place. However, a conviction cannot be based solely or substantially on an accused silence. Where inferences may be drawn from silence, the court must direct the jury as to the limits to the inferences which may properly be drawn from silence. Although in my view, the right to silence in the Turks and Caicos Islands is absolute, Section 80 of the Criminal Procedure Rules, and these rules were enacted in 2021 and the 1st of August, it requires the defense to provide the prosecution with a defense statement after the defense has received disclosure from the prosecution. In fact, Section 80, subsection 3 says, the accused shall, where the prosecutor has complied with Rule 79, file and serve a defense statement on the prosecutor and the court on the date fixed in the scheduling order. Subsection 4 says, for the purposes of this rule, a defense statement is a written statement, A, setting out in general terms the nature of the accused's defense, B, indicating matters on which he or she takes issue with the prosecution, and C, setting out in the case of each such matter the reason why he or she takes issue with the prosecution, and signed by the defendant and his attorney. Now, there are some legal scholars and practitioners in the Turks and Caicos who believe that this section could come into conflict with the constitutional provision that guarantees an accused person the absolute right to silence. These are matters that may be litigated in court at a later stage. However, I promise to deal with the rules or the criminal procedure rules in a subsequent episode. In relation to persons questioned by the Serious Frauds Office in the United Kingdom, the right to silence has been reduced by virtue of Section 2 of the Criminal Justice Act of 1987. The right has also been reduced for those persons accused of terrorism offenses. Notices under the Criminal Justice Act of 1987, by virtue of Section 2, subsection 2, gives the Director of the Serious Fraud Office or a designated person the power to require a person or an entity to provide information or answers during questions in an investigation where they have reasonable grounds to suspect an offense has been committed involving serious or complex fraud or corruption. Therefore, there is no absolute right to silence in England and Wales. It appears that the country that gave the world, or that gave the Turks and Caicos Islands the right to silence, has constantly eroded and curtailed that right. Thank you for listening.